I'm Scott Lachlan. This is the Data Chronicles, and here are your data points. Today, we are continuing our series on building the AI lawyer's skill set. This time with the discussion of the impact that artificial intelligence is having on US copyright law. Listeners know that artificial intelligence impacts almost every area of law, which makes practicing AI law difficult. You effectively need to know enough about everything and issue spot along the way. The Data Chronicles is here to help with episodes that cover the many legal issues that AI is raising and how to spot the issues across all of those disciplines. And today we're going to focus on US copyright law, for which I've invited my colleague, Lauren Curry, to the podcast. Lauren's practice focuses on copyrights, IP, and IP litigation. She has been on the podcast before to discuss things like web scraping, and I'm so excited to have her on today's episode. Lauren, welcome back to the podcast.
Thanks for having me back, Scott.
Lauren, why don't we just start maybe at a high level? I mean, you can explain what are the issues that artificial intelligence is having specifically on US copyright law?
So with respect to AI's implications for copyright specifically, we like to think of those implications as falling into two different buckets. First, on the input or training side of AI, and then second, on the output side. So with respect to training, what we're talking about relates to largely the scraping, training, copying practices, arguable copyright practices that AI systems engage in order to learn from the data and text and images and metadata that they train on. Then on the output side, what we're looking at are copyright implications with respect to copyright ownership in the output of AI models, as well as potential infringement concerns relating to the use of that output.
So if I'm thinking about that correctly, Lauren, you need to be able to think about US copyright law all through the development and use of artificial intelligence and artificial intelligence engines. And that's starting from the time where it's being created.
That's right. And it's, not just the creator of the AI systems, but also the companies and businesses who are using the AI systems and using the output of AI systems. So really a broad spectrum of applicability in the copyright world.
And so then if I'm thinking about that, in order to be able to dissect and identify, how these issues are playing out in connection with the training, one important component is going to be to understand the data that's being inputted and what are the rights that you have with respect to that information, which is an area in my practice on privacy and data security, which often comes up, but it sounds like that's also a similar issue that you're working through on the copyright side.
It is. And it's really the issue that has taken center stage in the copyright world. And that's the question of whether the generative AI models training practices, so training on third-party data and text and materials that in many instances is copyrighted, constitutes fair use or a defense to copyright infringement under US copyright law. So just to back up a little bit, the way that many of these models work is by analyzing large swaths of data, and in most cases, third-party data, just because of the size of the data sets that's necessary for these models to work. Much of that data, either in the form of text or images, implicates third-party copyrights. And so the question becomes whether using that data to train, in the context of which often copies, sometimes intermediate copies, sometimes more long-standing copies may be made, whether that qualifies as fair use.
So how do I do that? I mean, in other words, if the data is coming in from so many different sources and you're creating these LLMs, which is likely going to involve potential intellectual property owned by many individuals, how does an AI lawyer think about that question to even identify what rights attach to the data that we would like to use as part of the training data set?
There are a few different ways I think that we need to think about it. So first, I think we need to acknowledge that this is very much an open question of law. So there are close to 24 litigations, largely class action litigations, that are pending before the courts right now on the question of whether training practices do in fact constitute copyright infringement or whether they fall within the fair use defense. So generally speaking, it's just an open question of law that I think the industry is watching very, very closely with much anticipation. But in some respect, we're just waiting to find out how the courts are going to rule on this issue. While we're waiting, there are some things to think about and bear in mind in order to mitigate that risk. I think the only surefire way to make sure that you aren't infringing on third-party rights with respect to the training data that you're using is to get a license to that training data and to make sure that that license covers the training practices that you're engaging in. So license terms, of course, can vary from license to license. They can permit certain uses and exclude others. And so if you want to be absolutely sure that you're able to train on the data in text and images and whatever it is that you're training on, a training license is really right now the only way to mitigate that risk. Unless, of course, you're using your own data, which becomes complicated just by virtue of the nature of these large language models and how much data they tend to require. The other thing we can think about in terms of mitigating risk, which is sort of in the middle of the spectrum between just waiting and watching to see what happens and then, getting a full-blown license for all of the data that you're using, is to make sure that you're not training on material that includes either opt-out, material that's either been opted out of training practices, either contractually or through license, or that has metadata or meta tags that say do not train. In our experience, those sorts of materials implicate a higher risk potentially with respect to willfulness. So that's another thing to watch out and be thinking about as we're waiting for the courts to come down on this issue.
So how does an organization try to identify those tags or that metadata to be able to identify what they can train on and what they can't train on, even if that was the metric?
From what we've seen, it's largely a technological measure. So training your crawlers and your scrapers to identify those sorts of tags and to move past them instead of ingesting them and scraping them. The other thing I should mention is that in addition to traditional copyright infringement claims, what we're seeing on the input side are DMCA or Digital Millennium Copyright Act claims as well. Those are a little bit more straightforward than the copyright infringement claims. They don't implicate the same fair use considerations. There is no fair use exception under the DMCA. And the claims that we're seeing there relate specifically to this metadata and these meta tags that we're talking about now. So claims, for example, that copyright management information like metadata has been removed from the training material, or that protection measures, technological protection measures have been bypassed in order to scrape that material. So those are other things along with looking out for those meta tags and metadata that it's good for practitioners and businesses to be aware of.
So, Lauren, it sounds like one of the root problems on the input side is to try to understand the provenance of all of the data that's being collected and the rights that others may have to that data, together with the rights that you have with respect to that data. And I think an added challenge is that oftentimes the data that you're looking to obtain is really just the collection of data that came from multiple different sources. So trying to decipher whose data belongs to whom seems to me is near impossible. And sounds like that is an issue that the courts are being asked to address.
Exactly. And I'll caveat these considerations with respect to the challenges here and the importance of understanding the provenance of data with the reality that this is an open question before the courts. And if the courts do come down and say that AI training practices qualify under the fair use exception to copyright infringement, many of those concerns, I think, are likely to be quashed. It will be fact dependent, I think, to a certain extent, depending on how the different models technologically train on data and whether there are copies made and intermediate copies made and how those copies are hosted. But depending on the scope of any fair use decision and how that fair use decision comes out, I think much of this is subject to change. But yes, based on where things stand right now, in terms of mitigating risk, the understanding the provenance of the data that you're training on and the different rights that various different rights holders may hold in them is of utmost importance.
So then let's talk about what fair use means in this context. If I think about fair use, it's oftentimes in the context of maybe all of our educational experiences that we've ever had about, how much can you cite to back to copyrighted sources as being a potential fair use. But my guess is that there is actually a fair amount of developed case law and that you can look to understand what fair use means. Is there anything that speaks to fair use in connection with artificial intelligence?
Not yet directly, but there are certainly a number of cases that establish the standard for fair use and the factors that are to be evaluated under the fair use analysis, as well as cases that go to the considerations around fair use and arguments that have been made both on the plaintiff and defense side of these cases that we're seeing. So, in terms of the legal test, it's a judicial test, so subject to judicial interpretation, which I think raises some of the uncertainty and variability here and provides the flexibility under the fair use analysis that I think is both a boon and frustration under US copyright law. But those factors are the purpose and character of the use, the nature of the copyrighted work, which here would be the work that's being trained on, the amount and substantiality of copying, so whether an entire work is being copied or whether only part of it is being copied, and then the effect on the potential market or value for that copied work. And so we're seeing different arguments on both sides from both the plaintiffs and defendants, applying those factors as well as existing case law that I'd be happy to walk through if that would be of interest.
Yeah, I mean, I'm interested in kind of any insights about where you think you're going, but I also want to make sure we don't lose sight of the second half of this equation. So I think you started by saying, hey, there's really two things that you need to be thinking about with respect to copyright and AI, inputs and outputs. So love your take also about how the copyright issues that are being created with the outputs of the use of these technologies.
Absolutely. So on the output side, we're really looking at two concerns. First, can you own the output of generative AI from a copyright perspective? So if you use a generative AI tool to write a book or develop software code or create images or illustrations, can you copyright those things? And then the second question is, when you use the output of generative AI, given the way generative AI is trained, including on potential third-party materials, including materials that possibly weren't licensed, are you opening yourself up to liability for infringement based on use of that output? So the first one is actually subject to Copyright Office policy that continues to evolve and has been really, really interesting.
So ownership and then infringement. Ownership sounds like that's been an issue that the Copyright Office has taken on directly.
They have taken it on directly, although it continues to evolve. So when generative AI first started to be widely adopted at the beginning of last year at this point, the Copyright Office scrambled a bit to issue an initial policy with respect to whether or not you can own copyright in AI output. This was in March of 2023. And what they did was they came out with a fairly bright line approach that said you can only own copyrights in things that are the subject of human authorship. The output of generative AI is not the subject of human authorship, and so you can't own copyrights in it. And that creates a kind of bizarre situation where if I use generative AI to create an image, and then I take that same image and I create it using Photoshop or some other image editing tool, the generative AI created image is not something that I could own a copyright in, but the Photoshop created image is, even if they're identical, even though they were both created through the use of some sort of technological tool. And so the industry had a pretty robust reaction to this policy. I think the Copyright Office received a lot of pushback. I think people thought that maybe there was too bright of a line. And the Copyright Office issued a notice of inquiry at the end of last year to the public on this issue, as well as several other of the copyright issues that are pending, including before the courts. And they received over 9,500 comments in response to that notice of inquiry. And so there's been a sense, since that notice of inquiry closed at the end of last year, that a new policy may be emerging from the Copyright Office. And we did actually just receive a decision from the Copyright Office just a couple of weeks ago that provides what we think is maybe a window into where that policy may be headed.
Thoughts on where it would go?
Yeah, so the decision that came out of the Copyright Office related to textual work, a book that was drafted by a disabled veteran, Eliza Shoup. And Ms. Shoup used ChatGPT, one of the generative AI tools, to create first drafts of the sentences for her books. She claimed that she then heavily revised those sentences and compiled them into her text as a whole to create a book that she self-published and sought copyright protection for. When she initially filed her application with the Copyright Office for registration, the Copyright Office came back under their current policy and said, no, this is output from generative AI. It's not the subject of human authorship. You can't copyright it. She then appealed. She raised interesting arguments with respect to the Americans with Disabilities Act and whether her use of ChatGPT was as an assistive device, which raises really interesting considerations as to the intersection between copyright policy and the ADA, but we can leave that for another podcast. But what the Copyright Office ultimately did is they reached a little bit of a middle ground. And they said, okay, we're not going to grant you a copyright over the text itself, the sentences themselves that were created through the use of generative AI, but we will grant you a compilation copyright. So we are going to give you copyright protection in your selection and arrangement of those generative AI created sentences into the book as a whole. And this is an extension of a decision that had issued earlier, actually just before the Copyright Office's initial policy, where they also granted a compilation registration with respect to a graphic novel and the images compiled in that graphic novel, which images themselves have been created through generative AI. But the extension of this to a textual work, we think may be a window into where the Copyright Office is headed, at least as an intermediate step in this area.
I mean, I got to imagine that that's going to be very difficult to effectuate, right? In other words, to try to implement that type of analysis. The thing about generative AI itself is it's very difficult to understand what was created via generative AI versus what was created by a human. It's not like there's any type of fingerprinting or attribution at the moment. So how to then sort out what was computer assisted generation versus what was human, and then how to think about that within one large compilation of materials.
I think that raises the two big issues that we're going to see and are seeing in this area with respect to copyright ownership. First, on the Copyright Office side, how do they know? How do they decide how they're going to grant registrations in this space? And the way we're seeing them deal with this is with all sorts of registration requirements. So affirmative requirements that applicants disclose their use of generative AI in the creation of works that they seek to copyright. And of course, if they fail to disclose that and they later seek to enforce their copyrights, there's going to be discovery into that creation. Their copyright registrations could be at issue. We do expect that ultimately, when, not if, but when these copyright registrations are litigated, there's going to be a lot of discovery into exactly what role generative AI played. And that's likely to be where that role comes out factually outside of the disclosures that are made to the Copyright Office. The other big question, which is outside of the Copyright Office, I think goes to your point of what does this actually protect? So when the Copyright Office grants a compilation registration for a textual work, so the selection, arrangement, compilation of different AI generated sentences, but not the sentences themselves, or the selection arrangement of AI generated images, but not the images themselves. What exactly is the scope of that protection? And that, again, is where we expect there's going to be a lot of litigation as to what these registrations do and don't cover, particularly when registrants seek to enforce them.
I mean, I think that it will be very kind of interesting then to watch the developments in this particular space. I mean, I'm also interested then and say, all right, well, there are potential limits on what is it that you can own that comes out of an AI tool. But if we go back to the other half of the issue that you spotted, is there liability with the potential use of the tool, right? So even if I can't feel like I can get the value or protect the value of the tool, does the fact that I use the tool to begin with, could that result in liability?
What we're seeing, at least on a theoretical level, again, the courts haven't come down on this, but at least on a theoretical level, it can, right? So if, for example, an AI tool trains on one particular image, and we can refer to the Getty Images case. I mean, that's the most well-known. It's been filed here. It's also been filed in the UK. It trains on an image that is copyrighted by a third party. And then on the output side, spits out something that is substantially similar, which is the test under US copyright law, to that original image. Then you, as the user of the AI tool, even though you don't know that that particular image is substantially similar to one that the tool was trained on and that is copyrighted by a third party by using that image, by copying it, by publishing it, by reproducing it, by creating a derivative work from it, you could arguably be infringing that original image that the AI tool trained on. Other big concerns come in the software space in particular, where tools are training on third-party code, including code that might be subject to open source licenses, and maybe spitting out code on the output side that would arguably be subject to those same open source licenses. And so you may then be adopting and using code that is subject to a license that you're unaware of in a way that is in breach of that license or non-conforming to that license, exposing yourself to liability there as well. And we've seen tools try to deal with this in a number of different respects. We've seen filters that certain tools will apply to their output to try to make sure they're at least a certain distance away from anything that's been input into them. We've seen indemnification programs that have been started to be implemented in connection with certain tools that say, if you do these certain things, if you use our filters, if you don't include prompts that are, for example, designed to solicit what's likely to be infringing material. And there are a whole list of caveats with respect to the indemnifications, but they will indemnify you for any use of their output that is deemed to be infringing under those circumstances. So it's definitely on the top of both developers' minds as well as users' minds.
So, I mean, it's this portrait that I think you have helped us paint, and at least in my mind, is one of like, boy, I have to be concerned about IP, particularly with copyrights throughout the development cycle. I know that it's going to be issues with my creation of these tools, my use of these tools, and present potential limited value. And how is it that I can protect the outputs from these tools? I guess I go back to this main question of like, well, thing about it is that it's very difficult to attribute any uses of AI, any uses of data for training, any uses of data that may be infringing somebody else's copyright. How do you think these issues will present themselves in the future? I know that the law here is unsettled, but as it starts to become settled, where do you feel like the facts are going to land where somebody is identified as being using these tools in potential violation of somebody else's copyright, which then results in some form of litigation?
I think what we're seeing is a focus on the prompts themselves that are used, including with respect to the intent of the particular user. So, for example, if you are inputting prompts that are directed at creating a particular copyrighted work or copy of a copyrighted work, I think the courts are going to look much more skeptically on any argument that you try to make that you didn't know that the output was infringing or any infringement was innocent. I think it's going to be harder if the prompts that you input were, say, neutral. They weren't, they didn't name a particular artist, for example, or ask for something in the style of X, or ask, basically paint a description of a copyright character without using that copyrighted character's name. I think it's going to be much more challenging where in that situation, the output of a tool is arguably infringing or is accused of infringement and the user didn't know and didn't prompt that infringement. I think, what we're likely to see there are questions of who is liable for that. Is it really going to be the end user who used these tools innocently, particularly if they used filters that were available and tried to avoid infringement? I think that's going to be a fact in their favor. But is it really them who's more liable, or is it the tool developer, or is it the company that made the tool available? We've seen a lot of vicarious liability asserted in these cases. We've seen contributory liability asserted in these cases. So I think in that instance, that may be where we see these claims go.
We're going to have a future episode in this series relating to how to negotiate contracts with the providers of these tools, or if you are a provider of the tools, how are you going to negotiate contracts with the users of those tools? And my guess is that all of these IP issues are really going to be front and center as part of any of those types of negotiations. Interested also, Lauren, in your perspective, where does all of this uncertainty plus the combination of the uncertainty and the real world articulation of the risks, where does it leave us? Have there been strategies that you have been identifying to help in the short term while some of the legal uncertainties are solved?
Yeah, so I think it's a balancing act because you don't want to fall behind in terms of use of this technology, which everyone wants to leverage because of its benefits and the ability to, increase efficiencies and, create new product and use this technology as, frankly, the majority of the market is now. So you don't want to find yourself in a position where you're being sort of so risk adverse that you're not able to leverage the benefits of the technology at all. But you also don't want to be really at the front of the pack in terms of use of the technology and how you're using it and what you're doing with it, because that's, where we're seeing a lot of litigation happen. So what we're seeing is sort of a balancing act of trying to leverage the technology, but leverage it in sort of middle of the road way. And there are a number of different ways that we're seeing companies try to do that. From the company perspective, we're seeing a lot of use policies being developed and implemented. So generative AI use policies in terms of how individuals at a company are able to use the tools, which tools they're able to use, whether they're able to use it to create product or external facing things, or whether, use can only be internal. A lot of personnel training around those policies and around that use, what can and can't be input into different tools, for example. And that will go to things like confidentiality, as well as potential waivers of different IP protections. We're seeing companies be very careful with the tools that they allow their employees to use. So we're seeing enterprise agreements being negotiated, which I'm sure will be discussed in this later podcast. We're seeing sort of sandbox tools, so tools that only draw from and pull from and produce from within the organization, which mitigates some of these risks. I mentioned earlier that a lot of these tools now have filters on the output side to try to mitigate against the risk that what they're producing may be infringing of something that they've trained on. So, companies are instituting policies or only selecting tools that have those sorts of filters. And we're also seeing a lot of awareness around the indemnification agreements that are starting to come out, and a comparison of those indemnification agreements and analyses of those indemnification agreements to try to understand which indemnifications are likely to offer the coverage that specific to the organization or the use cases of the organization is most likely to be beneficial.
Yeah, I think one of the things that we've discussed on a prior episode is the role of a governance program that would bring some sort of order and process surrounding all of the things that you're describing. Key to a successful governance process in this is to have the right stakeholders involved, including intellectual property expertise. Interested in your perspective on what the right role is for the IP lawyers to bring to that governance process, and how is it that those who are pushing forward that governance practice as being the AI lawyers amongst the group can be able to best leverage that expertise?
I think it mirrors to a large extent what we're seeing in the litigation and the issues that are coming up in the litigation that's pending before the courts. So if you are the IP lawyer involved in this core AI group within your organization in charge of or contributing to this governance process, you're going to want to make sure, for example, that you understand what the training data that, if you're developing a tool or you're using a third-party tool, what that training data set looks like, what the rights are in that training data set, what representations are being made to you as a user of the tool with respect to that training set and the rights in that training set, and whether there's a risk that they may be infringing. And if there is that risk, whether there are indemnification provisions around that the tool is offering you. One of the things that we've seen clients do or come up, for example, with a third-party tool risk assessment framework, where you can actually score different third-party tools across the metrics that are most important to your organization for any particular use case to decide which one is most important for you. And we've seen those specific to IP, as well as many of the other issues that AI touches upon that I know we'll be addressing through this podcast series. So I think on the input side, making sure there's that understanding, not just of what the training data set is, but also what protections, if any, you are being offered as the user of the tool with respect to that training set. Then on the output side, and this will be really important in the organizational context, making sure that there is a framework and guardrails around how generative AI output is used and how that use is being documented. So while the ability to own AI output is in flux, we've been advising clients to really keep a record of how they use AI tools to develop any external facing products or products that they may later want to claim rights in, including things like marketing materials, but also software or products more broadly, so that in the event the Copyright Office's policy does shift and you are later able to hold copyrights in the output of AI, whatever use you have made of AI in that process has been documented so that you can leverage that in applying for registration. In the meantime, making sure that if there is something that you want to protect under copyright or that you wouldn't want copied, that you're not using the direct output of generative AI or an arguable derivative of that output in those things. So if you are creating software, for example, making sure that none of the code that comes out of a generative AI tool is being copied and pasted into a software product that you're going to want to copyright in the immediate term or claim protection in, just because of the limitations in the Copyright Office's current policy. Same thing with marketing materials. If you're developing marketing materials that you wouldn't want a third-party competitor to use, for example, making sure that you're not using a generative AI tool to generate the images for those marketing materials or the copy for those ads. So really guardrails on both sides of the process there.
Yeah. And then maybe my last question is the other issue that I think people in the space are worried about. And that is, if an organization were to unintentionally perhaps load their copyrighted materials into a platform like this without necessarily agreements in place, what does that mean for their ability of exerting the continued copyright protection? There's been prominent stories of developers in the software space from them kind of putting in a bunch of proprietary code into commercially available tools. Does that mean that they potentially have no longer any copyright protection with respect to that uploaded data?
It's a really interesting question. So I think in the trade secret context, you are waiving that right? Because you're making an affirmative disclosure. Copyright is a little bit different, and I think it may depend on the terms of use of the particular tool that you're using, because just because you take a copyrighted work of yours and you put it out there in the public, say you publish it on the internet, or you post it on the street corner, or you hang it in a museum, or you otherwise make it publicly accessible, you're not waiving your copyright rights in it. And I could see an argument that that's similar to what you're doing in the context of providing training data to an AI tool. Now, if the terms of use of that AI tool say that in allowing us to train on whatever information you're providing, you hereby assign all of your copyrights to us, and if there are provisions around those rights, I think it's different. But in terms of the disclosure of copyrighted works to AI tools themselves for training purposes, I don't know that it's necessarily a waiver of those rights like it would be, for example, in the trade secret context, where the disclosure itself is what becomes the operative issue.
Yeah, really interesting space, Lauren. And I'm sure there's going to be a lot of issues to come, so worth really tracking closely. Really appreciate your time and expertise on this. This is one installment of a number of episodes that we have on the Data Chronicles relating to how to build out AI lawyers' skill sets. One of the past guests had made the point that in order for you to be able to practice AI law, you need to know so much, and copyright, IP, trade secrets all kind of fall into those camps of core learnings to be able to practice in the space successfully. And so I appreciate your sharing your expertise and knowledge with our audience.
Thank you for having me.
With that, I'm Scott Laughlin. This is the Data Chronicles, and those are your data points.